The covenant entered into force for India on 10 July 1979 and for Pakistan on 23 September 2010. In this respect, the Court observes that its jurisdiction in the present case arises from Article 1 of the optional protocol and therefore does not extend to the determination of breaches of international law obligations other than those under the Vienna Convention. This conclusion does not preclude the Court from taking into account other obligations under international law insofar as they are relevant to the interpretation of the Vienna Convention. In light of the foregoing, the Court finds that it has jurisdiction under Article 1 of the optional protocol to entertain India's claims based on alleged violations of the Vienna Convention. The Court now turns to the admissibility of the application. Pakistan has raised 3 objections to the admissibility of India's application. These objections are based on India's alleged abuse of process, abuse of rights, and unlawful conduct. The Court addresses each of these objections in turn. In its first objection to the admissibility of India's application, Pakistan asks the Court to rule that India has abused the Court's procedures. Pakistan advances 2 main arguments to this end. First, it alleges that when requesting the indication of provisional measures on 8 May 2017, India failed to draw the Court's attention to the existence of a constitutional right to lodge a clemency petition. Secondly, Pakistan submits that before instituting proceedings on 8 May 2017, India had failed to give consideration to other dispute settlement mechanisms envisaged in Articles 2 and 3 of the optional protocol. The Court observes, in relation to Pakistan's first argument, that in its order indicating provisional measures, it took into account the possible consequences for Mr. Yadav's situation of the availability under Pakistani law of any appeal or petition procedure, including the clemency petition to which Pakistan refers in support of its claim. In this regard, the Court concluded inter alia, I quote, that there was considerable uncertainty as to when a decision on any appeal or petition could be rendered, and if the sentence is maintained, as to when Mr. Yadav could be executed, end of quote. Therefore, there is no basis to conclude that India abused its procedural rights when requesting the Court to indicate provisional measures in this case. In relation to the second argument, the Court notes that none of the provisions of the optional protocol relied on by Pakistan contain preconditions to the Court's exercise of its jurisdiction. The Court interpreted these provisions in the case concerning United States diplomatic and consular staff in Tehran, where it ruled that Articles 2 and 3 of the optional protocol to the Vienna Convention on diplomatic relations and to the Vienna Convention on consular relations laid down, and I quote, a precondition of the applicability of the precise and categorical provision contained in Article 1, establishing the compulsory jurisdiction of the court in respect of disputes arising out of the interpretation or application of the Vienna Convention in question. Articles 2 and 3 provide only that as a substitute for recourse to the court, the parties may agree upon resort either to arbitration or to conciliation. End of quote. It follows that India was under no obligation in the present case to consider other dispute settlement mechanisms prior to instituting proceedings before the court on 8 May 2017. Thus, Pakistan's objection based on the alleged non-compliance by India with Articles 2 and 3 of the optional protocol cannot be upheld. The court recalls that only in exceptional circumstances should it reject a claim based on a valid title of jurisdiction on the ground of abuse of process. In this regard, there has to be clear evidence that the applicant's conduct amounts to an abuse of process. The court does not consider that in the present case there are such exceptional circumstances that would warrant rejecting India's claims on the ground of abuse of process. Accordingly, the court finds that Pakistan's first objection to the admissibility of India's application must be rejected. With regard to the second objection to the admissibility of India's application, Pakistan requests the court to rule that India has abused various rights it has under international law. In its pleadings, Pakistan has based this objection on three main arguments. First, it refers to India's refusal to provide evidence of Mr. Yadav's Indian nationality by means of his actual passport in his real name, even though it has a duty to do so. Secondly, Pakistan mentions India's failure to engage with its request for assistance in relation to the criminal investigations into Mr. Yadav's activities. Thirdly, Pakistan alleges that India authorized Mr. Yadav to cross the Indian border with, I quote, a false cover name, authentic passport, end of quote, in order to conduct espionage and terrorist activities. In relation to these arguments, Pakistan invokes various counter-terrorism obligations set out in Security Council Resolution 1373 of 2001. In its judgment on the preliminary objections in the case concerning immunities and criminal proceedings, the court ruled that abuse of rights cannot be invoked as a ground of inadmissibility when the establishment of the right in question is properly a matter for the merits. The court notes, however, that by raising the argument that India has not provided the actual passport in Mr. Yadav's real name, Pakistan appears to suggest that India has failed to prove Mr. Yadav's nationality. This argument is relevant to the claims based on Article 36 of the Vienna Convention in relation to Mr. Yadav, and therefore must be addressed at this stage. In this respect, the court observes that the evidence before it shows that both parties have considered Mr. Yadav to be an Indian national. Indeed, Pakistan has so described Mr. Yadav on various occasions, including in its letter of assistance for criminal investigation against the Indian national Kulbhushan Yadav, addressed by the Ministry of Foreign Affairs of Pakistan on 23 January 2017 to the High Commission of India in Islamabad. Consequently, the court is satisfied that the evidence before it leaves no room for doubt that Mr. Yadav is of Indian nationality. As already indicated, the second and third arguments advanced by Pakistan in support of its second objection to the admissibility of the application are based on various alleged breaches of India's obligations under Security Council Resolution 1373 of 2001. In particular, Pakistan refers to India's failure to respond to Pakistan's request for mutual legal assistance with its criminal investigations into Mr. Yadav's espionage and terrorism activities, as well as the issuance of what Pakistan describes as, and I quote, a false cover name, authentic passport, end of quote. The court observes that, in essence, Pakistan seems to argue that India cannot request consular assistance with respect to Mr. Yadav, while at the same time it has violated other obligations under international law as a result of the aforementioned acts. While Pakistan has not clearly explained the link between these allegations and the rights invoked by India on the merits, it is the court's view that such allegations are properly a matter for the merits and therefore cannot be invoked as a ground of inadmissibility. For these reasons, the court finds that Pakistan's second objection to the admissibility of India's application must be rejected. The second and third arguments advanced by Pakistan will be addressed later when dealing with the merits. The court now turns to the third objection to the admissibility of India's application, whereby Pakistan asks the court to dismiss the application on the basis of India's alleged unlawful conduct. Relying on the doctrine of clean hands and the principles of ex turbi causa non oritur actio and ex injuria jus non oritur, Pakistan contends that India has failed to respond to its request for assistance with the investigation into Mr. Yadav's activities, that it has provided him with, I quote, a false cover name, authentic passport, and more generally, that it is responsible for Mr. Yadav's espionage and terrorism activities in Pakistan. The court does not consider that an objection based on the clean hands doctrine may by itself render an application based on a valid title of jurisdiction inadmissible. It recalls that in the case concerning certain Iranian assets, Islamic Republic of Iran versus United States of America, the court ruled that even if it were shown that the applicant's conduct was not beyond reproach, this would not be sufficient per se to uphold the objection to admissibility raised by the respondent on the basis of the clean hands doctrine. The court therefore concludes that Pakistan's objection based on the said doctrine must be rejected. The court further noticed that Pakistan has relied on the judgment of the Permanent Court of International Justice in the factory at Chorso case in order to advance an argument based on a principle to which it refers as ex turbi causa non oritur actio. However, in that case, the Permanent Court referred to a principle, and I quote, generally accepted in the jurisprudence of international arbitration, as well as by municipal courts, that one party cannot avail himself of the fact that the other has not fulfilled some obligation if the former party has, by some illegal act, prevented the latter from fulfilling the obligation in question. End of quote. With regard to this principle, the court is of the view that Pakistan has not explained how any of the wrongful acts allegedly committed by India may have prevented Pakistan from fully fulfilling its obligation in respect of the provision of consular assistance to Mr. Yadav. The court therefore finds that Pakistan's objection based on the principle of ex turbi causa non oritur actio cannot be upheld. This finding leads the court to a similar conclusion with regard to the principle of ex injuria jus non oritur, which stands for the proposition that unlawful conduct cannot modify the law applicable in the relations between the parties. In the view of the court, this principle is inapposite to the circumstances of the present case. Accordingly, the court finds that Pakistan's third objection to the admissibility of India's application must be rejected. In light of the foregoing, the court concludes that the three objections to the admissibility of the application raised by Pakistan must be rejected and that India's application is admissible. The court now turns to the merits of India's application. In this regard, the court recalls that Pakistan does not expressly raise any objection to the jurisdiction of the court. It notes, however, that Pakistan does advance several contentions concerning the applicability of certain provisions of the Vienna Convention to the case of Mr. Yadav. The court is appropriate to address these arguments first before turning to the alleged violations by Pakistan of its obligations under Article 36 of the Vienna Convention. The court notes that Pakistan's contentions regarding the applicability of the Vienna Convention are threefold. First, Pakistan argues that Article 36 of the Vienna Convention does not apply in prima facie cases of espionage. Secondly, Pakistan contends that customary international law governs cases of espionage in consular relations and allows states to make exceptions to the provisions on consular access contained in Article 36 of the Vienna Convention. Thirdly, Pakistan maintains that it is the 2008 agreement on consular access between India and Pakistan, rather than Article 36 of the Vienna Convention, which regulates consular access in the present case. The court will address each of these arguments in turn. With regard to Pakistan's first contention, the court begins by noting that India is not a party to the 1969 Vienna Convention on the Law of Treaties, whereas Pakistan signed that convention on 29 April 1970, but has not ratified it. Accordingly, the court will interpret the Vienna Convention on Consular Relations according to the customary rules of treaty interpretation, which, as it has stated on many occasions, are reflected in Articles 31 and 32 of the Vienna Convention on the Law of Treaties. The court observes that neither Article 36 nor any other provision of the Vienna Convention contains a reference to cases of espionage, nor does Article 36 exclude from its scope, when read in its context and in light of the object and purpose of the Convention, certain categories of persons, such as those suspected of espionage. The object and purpose of the Vienna Convention, as stated in its preamble, is to, I quote, contribute to the development of friendly relations among nations, end of quote. The purpose of Article 36, paragraph 1 of the Convention, as indicated in its introductory sentence, is to, I quote, facilitate the exercise of consular functions relating to nationalities of the sending state, end of quote. Consequently, consular officers may, in all cases, exercise the rights relating to consular access set out in that provision for the nationalities of the sending state. It would run counter to the purpose of that provision if the rights it provides could be disregarded when the receiving state alleges that a foreign national in its custody was involved in acts of espionage. The court thus concludes that when interpreted in accordance with the ordinary meaning to be given to the terms of the Vienna Convention, in their context and in light of its own, Article 36 of the Convention does not exclude from its scope certain categories of persons, such as those suspected of espionage. In view of this conclusion, the Court need not, in principle, resort to supplementary means of interpretation, such as the travaux préparatoires of the Vienna Convention and the circumstances of its conclusion, to determine the meaning of Article 36 of the Convention. However, as in other cases, the Court may have recourse to the travaux préparatoires in order to confirm its interpretation of Article 36 of the Vienna Convention. During the discussions of the International Law Commission on the topic of consular intercourse and immunities, there was no suggestion that Article 36 would not apply to certain categories of persons, such as those suspected of espionage. Draft Article 30A, which served as a basis for Article 36 of the Convention, was discussed by the Commission in 1960. It provided in the relevant part, and I quote, that the local authorities shall inform the consul of the sending state without delay when any national of that state is detained in custody within his district